Ready, start. We are of the opinion that the basis are the principle, if it can be called one, on which the writ petition has been allowed by the High Court is unsustainable in law and indefensible in principle. Full stop. Since we have come across many such instances, we think it necessary to deal with such pleas at a little length. Full stop. Generally speaking, the mere fact that the respondent authority has passed a particular order in the case of another person similarly situated can never be the ground for issuing a writ in favor of the petitioner on the plea of discrimination. Full stop. The order in favor of the other person might be legal and valid, or it might not be. Full stop. That has to be investigated first before it can be directed to be followed in the case of the petitioner. Full stop. If the order in favor of the other person is found to be contrary to law or not warranted in the facts and circumstances of his case, it is obvious that such illegal or unwarranted order cannot be made the basis of issuing a writ compelling the respondent authority to repeat the illegality or to pass another unwarranted order. Full stop. The extraordinary and discretionary power of the High Court cannot be exercised for such a purpose. Full stop. Merely because the respondent authority has passed one illegal slash unwarranted order, it does not entitle the High Court to compel the authority to repeat that illegality over again and again. Full stop. The illegal slash unwarranted action must be corrected, if it can be done according to law. Thus, indeed, wherever it is possible, the court should direct the appropriate authority to correct such wrong orders in accordance with law. But even if it cannot be corrected, it is difficult to see how it can be made a basis for its repetition. Full stop. By refusing to direct the respondent authority to repeat the illegality, the court is not condoning the earlier illegal act slash order, nor can such illegal order constitute the basis for a legitimate complaint of discrimination. Full stop. Giving effect to such pleas would be prejudicial to the interests of law and will do incalculable mischief to public interest. Full stop. In my view, it will be a negation of law and the rule of law. Full stop. Of course, if in the case the order in favor of the other person is found to be a lawful and justified one, it can be followed and a similar relief can be given to the petitioner if it is found that the petitioner's case is similar to the other person's case. Full stop. But then why examine another person's case in his absence rather than examining the case of the petitioner who is present before the court and seeking the relief? Full stop. Is it not more appropriate and convenient to examine the entitlement of the petitioner before the court to the relief asked for in the facts and circumstances of his case than to inquire into the correctness of the order made or action taken in another person's case, which other person is not before the case, nor is his case. Full stop. In our considered opinion, such a course, barring exceptional situations, would neither be advisable nor desirable. Full stop. In other words, the High Court cannot ignore the law and the well accepted norms governing the writ jurisdiction and say that because in one case a particular order has been passed or a particular action has been taken, the same must be repeated irrespective of the fact whether such an order or action is contrary to the law or otherwise. Full stop. Each case must be decided on its own merits, factual and legal, in accordance with the relevant legal principles. Full stop.